Yo, what is going on, everyone, in the XRP community? Hope you guys are having yourselves a fantastic day today. As usual, we got two major Ripple versus SEC documents from the XRP lawyer, James K. Fillon, which is amazing because he actually followed me back on Twitter. He wasn't following me on Twitter for a while. Just got the follow back recently. And same with Jeremy Hogan as like a few months ago. Anyways, guys, cryptocurrency market is down ticking a little bit, but it's nothing too major here. As you can see, it's just a % or two for the top 10 cryptocurrencies. I am sure we're going to be seeing a resurgence in these prices because these things have clearly on the daily chart. Bitcoin, Ethereum, XRP have all triple bottomed and have been attacking the resistance level. But then the sellers are stepping in a little bit. I am sure this is just a break and retest, and we're going to see the cryptocurrency market surge again soon. Not only that, but with XRP, we got, I think, in my opinion, we got the Ripple versus SEC case probably towards the end. I don't know what date it's going to be done. I'm not BitBoy. I'm not going to claim I have insider source. I know exactly when it's going to be done, but we got to be getting to the end of this considering Hinman emails are going to be released. However, I got an update for you guys here. Ripple defendants object to the SEC's request to impose an unprecedented level of secrecy on these proceedings by sealing all identifying information in the Daubert motions regarding its 5 preferred expert witnesses. As you know, the SEC, the reason why they want to hide the identities in these emails is because they're claiming that this is because they want to keep down the online threats and harassment. They want to keep that down because the XRP army, if you do wipe out $15 billion in market cap in like 3 days from suing us, yeah, we're going to have some people that are a little bit pissed off. So they want to hide the identities of multiple expert witnesses because they are claiming that this is for like personal protection and not having harassment and kind of attacks and threats basically on Twitter by the XRP army. Now, Ripple is actually objecting to this, and they are saying that the SEC is being way too secret about these proceedings by sealing all the identifying information in Daubert motions. Let's go ahead. Let's get some ultra zoom here, and let's speed read through this. I don't waste your guys' time. Dear Judge Shores, defendants, Ripple, right to oppose the SEC's request to impose an unprecedented level of secrecy on these proceedings by sealing all identifying information in the Daubert motions regarding its 5 preferred expert witnesses. The SEC's application should be denied subject to the very limited exceptions set forth below. The SEC's proposed redactions are the opposite of narrowly tailored. They would completely obscure the identity, educational background, employment history, publications, and professional affiliations of all the SEC's preferred experts from public view, despite such information being central to the resolution of the parties' Daubert motions. And despite some of that information already being public, the SEC cites no case, and defendants are aware of none, where a court sealed the identity and qualifications of an expert witness in the context of deciding a Daubert motion. This court should decline the invitation to become the first. The SEC claims this extreme step of sealing its experts' identities is needed as prophylactic measure to protect their safety and relies entirely on this court's prior ruling sealing certain information about SEC experts 1 and 5 in connection with the motion by Amici to access SEC's expert 1's report. But this motion to seal is distinguishable from the prior motion given the importance of the Daubert determinations in this matter, and the SEC provides no basis other than speculation for finding that disclosure of the experts' identities would trigger consequences that should override the substantial presumption of public access to these documents. Honestly, if they want to seal all the identities, we're going to see a lot of things being said that were not supposed to be public. But if we got those identities, that's going to allow us to connect the dots on more of this ETHgate stuff. Indeed, the available evidence suggests that disclosure of the experts' identities would not have the consequences the SEC suggests. Honestly, the only thing that's going to happen is you're going to get a couple of DMs from XRP Army members saying, oh, fuck you, man, you're a piece of shit. It's pretty much all they would get, essentially. For example, the SEC fails to acknowledge that the identity, reports, and deposition transcript of SEC Expert 5 have all been publicly available since at least March 2022. The SEC has not presented any evidence of conduct towards Expert 5 since that public filing in March that now justifies sealing swaths of the defendant's Daubert motions and Expert 5's already public reports and testimony. Let's go to the next one here. I don't know if I'm going to read this whole thing, but let's just see. The SEC does not contest that the expert reports and deposition transcripts at issue are judicial documents. These documents were filed in connection with the motions to exclude the testimony of these experts. going to skip past all this here. Because all the documents the SEC seeks to seal are judicial documents that were submitted in connection with a non-dispositive motion, they are entitled to a substantial presumption of public access under both common law and the First Amendment, citing Brown versus Maxwell. Although this presumption of access is somewhat lower than what dispositive motions, redactions still must be narrowly tailored to serve whatever purpose justifies the redaction. As this court has stated, the sealing of judicial documents may be justified with specific on-the-record findings that sealing is necessary to preserve higher values. The burden is on the moving party, here the SEC, to make the necessary particular and specific demonstration of facts showing that the disclosure would result in an injury sufficiently serious to warrant protection. That's the thing. It's like when I first heard about this narrowly tailored redactions, like I remember we first heard the Hinman documents, Hinman emails would be released. But then I heard the SEC is going to, narrowly tailor them. But it's like, what does that mean? Blacking out like 3 pages in a row? That's the thing. I don't want SEC to get too loose with the term narrowly tailored, because what do they think narrowly tailored is? Black out like, 9 paragraphs? Like, I don't want to see that. I want to see all of this public. All right. For all 5 of its preferred experts, the SEC speculates that the potential for threats or future online harassment justifies sealing their identities in Daubert motions as a prophylactic. I don't know what the fuck this word is, guys. I'm going to be honest with you. The SEC's expressed concerns are not supported by the kind of specific, compelling facts necessary to justify such an extraordinary sealing request. SEC experts 2, 3, and 4, the SEC has made no showing at all relating to these experts to justify its extensive proposed redactions. Expert 5, this seems like the most important one. This expert's identity is already publicly known and has been for several months, which I don't know who that is. Guys, let me know down in the comments below. His reports and deposition transcript have been filed on the public docket since March. The SEC has made no showing justifying sealing information that is already public. At most, they have identified a single non-threatening text messages from 3 months ago that only shows that someone reached out to the expert via text message to say the report was very flawed. Which doesn't even sound like a threat or harassment, honestly, but that's what the SEC's playing. They're playing the victim card. They want to wipe out $15 billion in market cap from us, then turn around and play the victim card. That's what I don't like. That sort of straightforward criticism does not suggest any danger to the expert and cannot justify sealing the expert's identity. Ripple is really not having it with the SEC now. They want everything public, dude, including the identities. Like, honestly, I agreed with the SEC. Like, hiding the identities, that kind of makes sense just because I'm not saying the XRP army is crazy, but I think there's some people out there that would go above and beyond with some, very explicit threats through Twitter and such. But honestly, Ripple's going, no, screw this. We want the identities revealed. And one of them's already public, which I'm confused because I don't know who that is. But if we can get all the experts identified along with what they're saying in these Hinman emails, dude, we are cracking down to the end of this Ripple versus SEC lawsuit. SEC Expert 1's identity is a high-level substance and has preferred opinion already publicly known, and indeed the name of SEC Expert 1 appears in the docket entries for 2 of the SEC's own filings in case to this day. At this point, the SEC redactions would be effectively futile. Guys, I'm not going to go ahead and waste your time and read all these documents here. I think we do get the point. We got one more tweet from James K. Fillon. SC versus Ripple, Amici filed response to SC's objection to their motion to participate in the expert challenges and to the SEC's motion to revoke their status and bar John Deaton from all further proceedings. It's absolutely hilarious. They are terrified of John Deaton. I don't really care to read what all the SEC has to say here because it's mostly beating around the bush. BS, but the fact that they want John Deaton thrown out the case just tells you they are scared and they are not ready to fight it out with the XRP army. They want us removed from the case because they're fucking scared. Last one for today, guys. Absolute shocker. United States Securities and Exchange Commission comes out and says, might as well give them a follow. Got to see what they're up to. Today we charged former U.S. Congressman Stephen Buyer with insider trading. Stephen Buyer buying up some insider trades. The name checks out, honestly. Has charged Stephen Buyer with insider trading related to his alleged use of non-public information to buy 1.5 million in stocks, and probably made like $3 million off of that. When insiders like Buyer, an attorney, a former prosecutor, and a retired congressman monetize their access to material non-public info, they not only violate the federal securities laws, but also undermine public trust and confidence in the fairness of our markets. Oh, and this is the guy, the Gruel guy, who we just saw on the SEC hearing live stream, but yeah, it's kind of funny because by making this announcement, they make it seem like, oh, it's only this guy. It's only this guy insider trading, nobody else. But, dude, Nancy Pelosi and her husband, man. Oh my God, how they have not been indicted yet. I don't know, dude, because it's painfully obvious. Like you got Twitter accounts specifically tracking Nancy Pelosi's portfolio so you can copy her trades and win. I mean, come on, man. Like I think her husband bought like 40 million of Nvidia and then a few weeks later enacted some sort of bill to seriously support Nvidia. It's just some bills to make Nvidia stock go up. And yeah, I don't know how the hell Nancy Pelosi has not been charged, but Stephen Buyer, let's see what he gets. The handcuffs or a 1 million slap on the wrist, free to go. All right, guys. Thank you for tuning in the video today. I would appreciate it. See you guys in the next one.